The subject of our panel is conflicts of interest, and I suspect that your first question is going to be, well, why do we care? Let me introduce my co-panelist, Henry Owsley. To my immediate left is the CEO and chairman of the Gordian Group. We also have Jeff Reich, who's a partner at Proskauer Rose in New York, and then finally Barry Ridings at Lazard. I think none of these guys needs any introduction. We want to talk about conflicts, and the reason that you should care about this is it really kind of hits most of us where we live. It's a question of, can we get retained, and are we going to get paid if we do get retained? And so that's kind of the real life the real life question for the end of this here. Let me set the stage, because I suspect that there's a lot of non-lawyers in the audience, and I suspect that you're kind of thinking, well, who cares? Conflicts, what's the problem? The issue is that the bankruptcy code requires that anybody who's going to be paid out of the estate, so either an investment banker or a lawyer for the company that's in Chapter 11, must be so-called disinterested. And disinterested means a bunch of things, including not having been an officer or director of the company. That's not usually a problem. But the real killer is that you have to not hold an interest materially adverse to the interests of any interest or any stakeholder in the estate. So what does that really mean? Clearly it means that the easy part is that it means you can't have a claim against the company that's filing, which means that if you are their lawyer or their investment banker and you've been working with the company for a while and they file Chapter 11, you better make sure you get paid first. They can't owe you money at the time that they file, because then you're a creditor and then you have an adverse claim. This can be dealt with in a number of ways. One of the subtler evolutions of that rule is the Pillow-Tex case of now a number of years ago. But you also have to be sure not only you're not a creditor on the day they file, but you got to make sure that you didn't get any payments that within the 3 months before the company files that could be recalled as a preference, because then you're a potential preference defendant and then you're not disinterested either. So various strategies for dealing with that, which we can get into if we have time. But how do you avoid, but does the disinterestedness go farther than that? What about a firm that has other clients who it doesn't represent obviously in connection with this debtor, but it does represent those clients, and those clients are creditors of this estate? The U.S. trustee has been taking the position that may very well constitute an adverse interest. If it's not a big enough relationship, it doesn't. But there have some decisions seem to indicate something approaching a zero tolerance policy for that kind of thing. Now, so that's the issue. The question is, how far does this disinterestedness requirement go? That's the law. Now I want to talk about, I think part of the panel we want to talk about real life. Who cares? What if you're not filing? Who cares about all this stuff? What if you just have a concern that maybe your advisors, if you're the company, maybe your advisors aren't going to be sufficiently aggressive on your behalf because they've got one eye out on the next deal and think, well, I don't want to tick off the big creditors in this whole scenario here, because maybe I'm going to be working for them soon. Do you have to make sure as the client that your advisors don't have conflicting interests or don't have a business plan of getting work from the company's biggest creditors? So I've been talking for long enough. First, let's talk about the out of court and the kind of real life scenarios. And I'm going to ask Henry if he could kick off with some thoughts about what a company should be concerned about, and what you potentially as investing in a company should be concerned about should there be trouble, or if there's already trouble. How do you look at your advisors or your potential advisors, and what concerns should you have as you're choosing among them?
Thank you, Katie. I'm going to address this to what the private equity firms of the world who are investing in these companies, because I think that is the starkest distinction here in terms of how the conflict of interest plays out. A lot of people in this business on the investment banking side have an active bondholder representation practice. And they will approach a company or its private equity backers and say, we can really help you with the amenities and social graces with your bondholders because we know them and we work for them. Well, if you hear that, put on your track shoes and start running. Because There could not be a more stark example of conflicts of interest, because a lot of lawyers and financial advisors who find themselves in that position are going to do an analysis after they're hired, conclude that the value waterfall stops somewhere in the bondholder class, tell the board that old equity is not going to be getting anything, and thanks for playing. We don't address it that way. Bondholders, we don't do bondholder work, so we can't get a call from a bondholder, giving some threat in the middle of the night. And we believe old equity has value, whether or not it passes the waterfall test. Old equity clearly has option value as well as control value. And we think that those indicia of value are worth preserving and fighting for.
Well, I think that's a really good point. There's kind of a control premium for existing equity, because at a minimum, they're the ones who've decided to put the company through a restructuring process, whether it's outside of court or in court. And I think Henry's exactly right. You can't. If somebody asked me recently what the biggest mistake that I have seen companies make in terms of trying to restructure, trying to avoid Chapter 11, which everybody, of course, always wants to avoid. Frankly, a lot of times even the advisors, because it's much easier to do these things out of court when you don't have the issue of the true disinterestedness, the legal standard that we'll talk about in a minute, and I raised before. And I said that the thing that I thought was the biggest problem, and I'm going to ask each of you, so be prepared, what you think the biggest problem is. What I think the biggest problem is listening to that statement that Henry just quoted. We have a great relation. Don't worry, we have a great relationship with the bank. Well, you do until you don't, and you will find out that you don't at a very inopportune moment. And so I think the idea that you can rely on, we worked with them in the last deal, we have a good relationship with them, we know these guys, we know how they think. I think that's probably the biggest the biggest shibboleth out there. Jeff, can I ask you to give your thoughts on that?
Sure. I think that one thing that we have all realized or know is that saying that you've worked opposite someone at the table in different deals does not guarantee you in any way kind of result. This is business. It may be your buddy who you deal with, but this is business, and you can't cut a deal that's on friendship. So I think when someone comes and tells you, that we deal with these people all the time, I think the most you can say is that they will know who I am, but you're not going to be able to get any favors as a result of that. The other thing I think, just a couple of points that you were making before, is one is that when we talk about conflicts, we can talk about them generally, but conflicts are very fact specific and context specific. So, we talk about these things, there are a lot of details that we may not have that might change the outcome. But also, I think you can't think about conflicts, in a pre-bankruptcy context without also thinking it in the post-bankruptcy context. If you play by one set of rules on the idea, or hoping that, well, we won't be in a formal court process, so this is what we won't worry about the disinterestedness issue for now. But fast forward 3-4 months from now, and you can't do the workout that you thought you were going to do. Your banks are breathing down your throat or down your neck, and guess what? You have to file. But then you go, oops, I have a conflict, and now I can't take you in. That is got to be probably the hardest and worst conversation with a client you could ever possibly have, because you now at their moment where they need you, you can't be there. So I think, even though you are in a pre-bankruptcy context, you do have to think long and hard about whether or not you can continue if you were to go into a process. And if you have a conflict, is it something that you can fix with a conflicts counsel or something of that sort? But you have to think about these things proactively.
Maybe to follow up on that, we often see that where the agent bank pitches the company and says, I can be your restructuring advisor and we'll get this all done out of court. And that happens all too frequently, that the company feels indebted to the agent, and then the agent can't get an uneconomic deal done, and they do find themselves exactly in the position that Jeff mentioned. Another point about what Henry mentioned, just to comment, again, most of the restructuring professionals tend to focus either on debtor or creditor. We at Lazard tend to focus on the debtor side. We don't do a lot of creditor work for some of the reasons Henry mentioned. I can't take a position in the morning for the benefit of a debtor and I flip it in the afternoon for the benefit of a creditor. If I'm in front of a judge, he's going to notice that difference. The second thing is that because we beat up the creditors in the morning, they don't really want to hire us in the afternoon. So they don't want to tell us our secrets in the afternoon that I can then use on them Tuesday morning. So you'll find most financial advisors tend to focus on one or the other. Where I do disagree with Henry is out of the money equity having some sort of intrinsic value. Out of the money equity has fiduciary duties to all creditors, not just the equity.
This is not a new argument between Barry and me, by the way.
No, we spar over this for the last 20 years, I think. But again, that's not a question of conflict of interest. That's just a question of how you're advocating for your client.
Although it does raise an interesting question for all of us as professionals, but I think particularly for the lawyers. At the end of the day, who is really your client? Because as Barry just mentioned, there are fiduciary duties and to all creditors, and creditors persistently and loudly make the argument to debtors' counsel and advisors all the time. Hey, wait a minute, who are you really working for here? The company hired you, but you can't expend too much energy trying to protect old equity, and old management, because they've got no economic interest here, and you should really be doing everything that we tell you to do. And the usual riposte that I give is, but I have to maximize value, and who's to say that your way is your preferred way is necessarily the way to maximize value, and then you get into the whole North LaSalle and auction and exposing it to the market. But I wanted to ask Barry and Henry a more subtle refinement of, okay, normally you do represent the debtor or the creditors, and you don't switch as facilely between the two as some lawyers are able to do, kind of on the basis that there are different facts in different cases. And I think Jeff and I are going to talk about that in a little bit. But have you ever had the situation where an individual within your firm is bounced out because a creditor dealt with you on the last deal and said, I feel like I didn't do as well as I otherwise might have because of that guy in your firm. He was really aggressive on behalf of your client. In that case, I would prefer not to see his or her face again. Does that happen?
We haven't had that experience. Again, I think it's largely because of what Barry was alluding to, is that some of us live on the debtor side of the equation and don't go back and forth. And, creditors are entitled to their opinion, but just because you were mean to them doesn't mean you're going to get bounced out of a case.
Or either that or that means that you're all mean at your firm. So,
Yeah,
so they just won't hire you.
we actually do see that, but it's a nuance. If we do a restructuring, the creditors usually get control of the company, control of the board, comes out of bankruptcy. And then, these hedge funds have an attention span like my grandson, really short, but they say it's 2 or 3 years. But in any event, they're looking for a way out, so they're going to sell it. Ironically, I guess it's not a surprise, we don't often get hired by that creditor-dominated board to sell the company. It usually goes to whoever represented the creditors when they did the bankruptcy.
Right.
Even though arguably someone else might have better qualifications to sell the company. So that's the way we see that.
But it isn't going to be you, whatever it is. You raised a point earlier about, Jeff raised the point about the horrible situation of having advised a company and then suddenly realizing, we can't put them in because we have a conflict. And that can happen, as Barry was saying, on the advisor side. The agent banks, they do this all the time. They say, well, we're your agent and we've provided financing for all these years. Just so happens that we have a restructuring group over here. How about hiring them, and how about entering into an engagement letter with them? Well, that's an absolute recipe for getting one or the other. It's going to be the investment, the advisor side. It's going to get bounced out if there's a filing unless the bank gets taken out because there's debt there. They clearly have an adverse interest. But of course, at the time that you sign the engagement letter, you've also signed up for some kind of tail provision. And depending on how much money you think, or how many cents on the dollar you think that unsecured creditors are going to recover in the case, that tail could be something that's material. And so it's a real problem when you now have to go out and hire another restructuring advisor, a financial advisor in the bankruptcy case. If they're successful, you're going to pay them, but there's also going to be a claim at least for the amount of the tail. And that's, as I said, if it's a 3 cent on the dollar case where value breaks pretty high up in the unsecured, it doesn't matter. But if there's a lot of value there, it can be a problem. Have you guys ever seen attempts to just abandon the tail or break the tail?
Yeah, that happens all the time, and because a company comes to you and say, well, I'm not going to pay your success fee because I'm on the hook for this other success fee. Well, we're not going to go work for free. So, what that does is push the debtor and or the debtor's attorney into going back and cutting a different deal with the prior advisor. That happens all the time.
Yeah, and again, another nuance, the way we see it, typically the agent bank, more often than not, is the DIP lender, and if we come in subsequent, that's one of the things we get a release from. Agent, release me on any claim if you want to do the DIP.
Right. Jeff, can you talk a little bit about whether you think ethics walls really work?
Well, I have to believe they do.
My formal position is.
Exactly. I've been put on the other side of walls in various matters, and if you have if you come from one firm to another and you have a matter that that there's a clear conflict that you can't take, the wall goes up, and you can't, and you obviously can't talk to people about it. In the case that I was involved in, the other attorneys were physically in another office on the other side of the country. They have to work. I think there's some issue under certainly some laws, whether or not those actually work as a matter of law. If not, the conflict is then imputed to the entire firm. So, as a practical matter, I think they do work because at least I've always operated under them. Maybe there's examples where in other places where the wall is given lip service, but I think it's the way all big firms will handle these matters. Otherwise, any small matter you'll get the full conflict out of.
Has any of us ever been asked to resign from a smaller matter in order to bring in the bigger matter that's clearly conflicted?
We've never put ourselves in this position. If we undertake an assignment, it's like you're married for life, and you're going to develop a pretty poor reputation if you jettison a client in order to take on another one.
Yeah, I agree with Henry. We'll usually, before we take on a matter, we'll look at, is this the right company we want to be with? Do we want to be with the debtor? Do we want to represent a potential buyer? And for us, it really focuses around the economics. Where do we have the highest chance of making the most money we can for the firm? Just one other comment about what Jeff said about what's the fear that we have about conflicts internally. And again, what I tell all of the guys in the restructuring group is that in the pecking order of the universe, there's God first, Archangel Michael second, bankruptcy judge third. If you cross a bankruptcy judge, he can put you in jail, but he can certainly ruin your career. So you need to be pretty darn careful if you're going to sign something in front of a judge. And again, the other thing in our business, if you break the rules, they often put you in jail for insider trading. So you have to be really, really careful in the investment banking world.
Yeah, that's an excellent point. The only thing I would add to that is that in that hierarchy, the U.S. trustee is fourth, and I want to go to that because I think there are really different views among professionals about how solicitous one should/has to be to the U.S. trustee, who, as we all know, is not a bankruptcy judge. But the judges don't really, unless someone brings something to the judge on a point of conflict, and God forbid you should ever get that far. My own view is that I will be very solicitous of the U.S. trustee. I will absolutely ensure the maximum amount of disclosure, even if I think it's irrelevant, even if the U.S. trustee has told me that he or she thinks it's probably irrelevant, I'm going to put it in my papers anyway. Because the last thing I want is, it would be very painful to not be able to be engaged in the first place, but the only thing more painful than that would be to incur a bunch of fees and get provisionally engaged, or be doing a lot of work in the weeks before the fee or the retention application comes up, and then find out I'm not going to get retained. So I don't think there's anybody. It was kind of like the earlier question about, are reporters going to be fair? Well, of course, we're all going to sit up here and say we're going to disclose, but I think that if you do a survey and you look and see what firms and what law firms and FA firms actually do disclose, I think you see a pretty wide variance. At least I've always gone toward the maximal disclosure, even if it makes really boring reading. Do you guys disagree with that?
I was going to say, Katie, that first of all, I can't, just for the record, I don't adopt that bankruptcy judge is a third in the pecking order. Okay? I would actually go a bit higher.
What's God done for you?
Exactly. So, but I think that of all the cases that you read, when law firms or professionals do something wrong on a disclosure issue, the issue is always they didn't do enough. Right. Either they decided on their own. Right. They decided on their own that it wasn't material, or that that the affiant wasn't told. Whatever it is, I mean, there's no downside to making more disclosure than you need to. And the truth is that the truth will set you free. And the more you disclose, the more you move past those issues. And I know no one's going to say no, you shouldn't be solicited as a U.S. trustee. But the bottom line is that's what they're there for. And on the first day of your case, when you stand up there before a judge, and there are also the rules, you don't get your retained on the first day anymore. But you don't want to have that be the issue. That's not going to be the driver of trying to get this company off the ground.
We had a matter where we were doing a pre-petition M&A deal, which would be followed by a bankruptcy to consummate it. And the U.S. trustee in our retention papers wanted us to disclose our relationship with each of the bidders and naming the bidders. And so we had a real problem with that. So what we ended up doing is we disclosed everything to the U.S. trustee, what the names were and what our relationship had been with those bidders on other deals, and just identified them by ABCD. They also wanted all the bids disclosed, which we said that doesn't work. So we ended up compromising with the U.S. trustee to make the transaction work. But they were definitely focused on, did Lazard have a prior relationship with any of the other bidders that were bidding on this company?
Yeah, I mean, I have the same experience. We over-disclose, as Jeff alluded to, and we've had to enter into negotiations with the U.S. trustee before on a variety of issues. And, it's painful, but my experience has been it always, in the end, gets worked out.
Yeah, no, I think that's exactly right. The only time it doesn't get worked out is if you don't go down that road and don't disclose. But, I think Barry raises a really interesting point, which is that if it's going to affect the actual, if it's going to screw up your attempt to get your sale approved, and you were doing an M&A process beforehand and then getting it confirmed, which of course is always tricky because the U.S. trustee is going to think, well, why don't you just file and then run a process? And there are a lot of good reasons for not doing that in particular cases. I want to go back before we start talking about the sort of in-court details, which we're going down a little bit now, about consistency. And Barry mentioned this. I think that attorneys and investment bankers / FAs have slightly different standards that they are held to in this regard. I feel as though it's easier for attorneys because we can say the facts of every case are different, and therefore it's okay for us to advocate one position in one case and take a seemingly contrary position, or at least advocate for a different side, if you will, of the same dispute in another case, even if it's in front of the same judge, because you can argue the facts are different. I do think the caveat to that, though, is if the facts aren't different, one does risk one's credibility in making an argument, especially before the same judge on a different side, a different case. But I think in terms of financial analysis that an FA does, you guys can't really do that, can you? You have to be pretty consistent because a DCF is a DCF. It's not going to change.
Yeah, you hit the head with that observation, because this comes up in valuation. And if you try to put, your finger on the scale too heavily, you're going to, it's going to come back and bite you in the very next case where, you're adding various things. You use the DCF. You're adding various risk premiums, which are inappropriate, and so on and so forth. And, actually, we've had some very interesting experiences in contested valuation hearings, where I've actually seen some people take some really aggressive positions. We see this a lot because we do a lot of litigation support work, and we feel that we need to be, extremely consistent, across the board.
Yeah, I agree 100%. Again, valuation is not it's not an advocacy position. It's generally accepted valuation techniques consistently applied. And then again, our check and balance internally is that no partner can go testify on an evaluation unless he's come back to the other partners to review his conclusions, and we have to make sure that he's crossed the T's and dotted the I's.
Well, and you raised the expert testimony and that whole thing, which is what I would like to get into next. So now we're transitioning into court world, where there's the permanent record, goes on your permanent record. You can always be found out about what you said in the prior cases that you've worked on, and I've not seen attorneys ever get pilloried with this, but you certainly see it with experts all the time, or at least people are attempting to do so. So I have a number of questions for the panel in this area, but I want to start with it was something that's become extremely popular, and I'm just not sure that it works. I certainly don't think it works for FAs, and I want to know what you guys think. But there's a whole idea of conflicts counsel. So the idea is that some of the larger law firms that range over many states and many countries and have literally tens of thousands of clients, it's got to be the rare situation in which that kind of firm represents a very large debtor with a huge number of creditors, a public company, and can honestly say we have absolutely no relationships with anybody who's had any claim against this company. It's almost laughable to think that you can. And of course you do all the searches that you can think of and all that, but you may not even know, you don't even know who all the equity holders are if it's a public company. Very difficult to find that out unless it's really quite closely held. So you make all those disclosures and all that, and then you say, well, we do have a relationship with XYZ Bank that has a claim, but anything that has to do with that bank, it's okay. We'll engage conflicts counsel, and that seems to go okay. You don't tend to see a lot of conflicts counsel actually standing up in court ever. At least I haven't. Jeff, what's your perception? And then I want to ask if you on the FA side, is there such a thing as a conflict FA? I've never seen it.
Well, I mean, this question came up in a case recently called the MF Global, where that question was asked, and the answer came back of, well, at least the law firm representing the trustee said conflicts counsels are an accepted use, and for the very reason that Katie was talking about. You can, if you're a big law firm and there's a bank or a large creditor that's probably represented by almost every other law firm in the city as well, it's going to be hard to find a law firm that can handle the size of the case that you need without having to engage conflicts counsel. I have seen it in action in cases where there's clear issues that primary debtors counsel won't go there. My view is that so long as that issue doesn't become the case, there's probably it can work efficiently. And I think in some jurisdictions, you almost have one built in. For example, if you're a non-Delaware firm and you go to Delaware, you're going to hire local counsel. You have one built in. From my perspective, the key is that you tell your client when you start the engagement, we can do the following things with this creditor. We can do the investigation, we can do the analysis, we can sit across the table, but we can't file a lawsuit. If they understand that, and again, it's disclosed to the court, I don't see a problem with it.
Yeah, I want to underscore something that Barry earlier alluded to, which is when you go into these cases, you're going to have to go in eyes wide open, because there really is, in my view, no effective conflicts financial advisor substitute. If you think there is a big conflict, you've got to think long and hard about taking on the engagement in the first place. And something else, one of the big parts of our job is to help the company identify, a course that it's going to steer by for the duration of the restructuring. And to the extent that that's going to roll over on some constituencies more than others, you need to be aware of that. And if it's going to cause some existing clients pain, you need to put that into your calculus of whether you are fit to undertake the assignment.
No, agreed. And it's a question of just disclosing all the relations you have with parties in interest. And kind of the two ones that are easy to think about. One, probably everybody does business with Verizon. So if Verizon is a creditor in a case and your firm uses Verizon, is that an issue? Well, you disclose it. It's probably not an issue. Now, let's say the lender to the debtor is JP Morgan and the lender to your firm is JP Morgan. Is that a conflict? Maybe yes, maybe no. You disclose it. And then it runs the full gamut. Have I done business with any of the board members for their companies? Again, all disclosable. And at some point, again, there are black and white conflicts, but on the gray ones, you kind of know it when you see it. It's really hard there's really no black and white, on something like that.
Well, and then that goes to the question that we started out with. Even if you're not in court, and even if you pass the true disinterestedness test, are you going to get a call some evening from the chair of your firm? Of course, you guys both are the chairs of your firm, so you don't have this problem. But but I could have this problem.
I'm not quite the chair of Lazard. I wish I was, but I'm not quite there yet.
Well, you're in that God hierarchy, you're pretty high up. I don't even make the top 10. So are you going to get a call saying, hey, I heard that you were being pretty aggressive in court, against a senior lender. I represent a lot of senior lenders. I don't represent that one, but I might like to. You think you could dial it back. And I think very rarely would you actually get that call, but certainly I think law firm heads kind of lie awake thinking about that stuff at night.
One of the issues you just touched on is that there's a distinction between a legal conflict and a business conflict. Right. Which is that it may be that you absolutely can. This will be approved by the court. It'll go through, but from a firm perspective, you can't. It'll anger the client so much that as a business matter, you won't take it, and it's a different type of conflict. And there's lots of unpleasant conversations that we all have, where we think there's an opportunity, and you can say, I can't believe that my partner thinks this is that we shouldn't be doing this, but that's navigating a political environment of a law firm as opposed to an in-court environment.
Yeah, well, I think that's right, and maybe things like that, conflicts like that mean that you never get to the court environment, but it's particularly galling, and this is just whining now, but it's particularly galling when a client who does not intend to hire you for the particular giant airline bankruptcy that just filed. Oh, what could I be speaking of? A client doesn't intend to hire you, but they also don't want you to pitch any other clients who are already in that case because they know that one of the big issues in the case is going to be something that they would not like to see you on the other side of. So, don't even think about going close to that case because we know they're going to challenge, some structure, and we have a structure like that too, and we wouldn't want you advocating to challenge that. Now, that's something that's never going to see the inside of a U.S. trustee's office because your firm is going to say, well, we don't want to anger. They're not hiring us for this, but we don't want them to never hire us again because we disregarded their wishes in that regard. So but you're right. It's definitely the distinction between an issue conflict or a business conflict and an actual legal conflict. So let's go to the always thorny issue of experts, and this is something that it has to be ingrained, because I always think of bankruptcy lawyers as not real litigators with air quotes around the real. And we don't tend to immediately think about these issues about experts, because we're always hoping that we'll just be allowed to testify to everything ourselves like usual, and that we won't actually have to get anybody up on the stand. But when you guys are contemplating, when you're hired contemplating that you will have to provide expert testimony, do you separate that? Do you designate someone as going to provide the testimony and that person doesn't talk to the attorneys? It's a little bit better now because the federal rules of evidence have been changed so that you don't have to provide all drafts of reports and all that. But do you do the kind of dual thing where there's one person who meets with the attorneys and talks about strategy and what we would like this report to say and all that, and then another person who kind of stays above the fray and remains so they can truly answer the question, well, did Ms. Coleman sit down and tell you what she wanted the valuation to be? They can say, I've never seen her before in my life. Do you do that, or do you implement it after the fact, or how does it work?
Yeah, what we'll do is we actually will separate the team. So the expert will drop out of any negotiations with the creditor. So the expert can't negotiate a settlement with a creditor. Someone else on the team negotiates that, and the expert will just focus on the valuation. And that's the way we cut it. But that's about the only way we cut it.
Yeah, we do pretty much the same thing, and we take the attorney's direction on this because, you know, the law firm will come to you and said, okay, who's going to be the testifier? We have a policy that the law firm pretty much gets to choose which of the partners is going to testify. So then if, you know, that person is going to be put in a closet and work, you know, one-on-one with the attorneys for however long, you know, the adverse proceeding continues, which in front of Judge Carey in the Spansion matter lasted a very long time. I was getting the smell of mothballs from the closet.
Yeah, have cedar blocks put in there to cover you. And what about what position do you take on expert reports? Do you have the attorneys draft them initially? Do you draft them and then show them to the attorneys? Do you refuse to let the attorneys anywhere near them? What's the policy there?
We let the attorneys take a look at them, but we view them as our material, not the attorney's material. And so we write virtually every draft, and you know we like, you know, any person you know, cherishes and, you know, good editing. So that's fine with us.
Right, same with us. We'll draft it. We'll show it to the attorneys for comment. But again, it's our report, and then we have our own internal check and balance to make sure we all sign off on it.
Right. Well, yeah. There's almost no good answer to well, who wrote this, and you don't want them sheepishly looking over at the attorneys and say, I see you looked over at your attorney, and then of course then there's the use of it going forward, and it's going to become a public document. Do you, and of course you can then be hoisted on your own petard, and you don't want to say in that next case, oh well, you know, the attorneys wrote that, I never saw it before in my life. Do you feel that the expert report is sometimes unnecessary? Do you try to, is it possible to avoid even having one?
It depends. It depends on how the case, the dynamics. You know, you need trial exhibits. Sometimes you need to explain the trial exhibits. A report comes in handy. You know, if you're going to be deposed, opposing attorney wants you to have as much in writing as you possibly can, so that you can be, you know, strung up on every single sentence you.
Right.
And again, it may sound a little perverse, but there's some firms we like going up against. So we're going to say a company's, for example, worth X, and they're going to say it's worth 5X. Maybe it could be worth 1.2X, but it can't be 5X. Right. That will be fun. The deposition will be fun. The testimony will be fun. So we actually enjoy those. They don't happen too often, but it's actually in direct proportion to the level of bankruptcies. The fewer the bankruptcies, the more litigation there seems to be somehow.
Yeah, that is certainly true. just proving that work expands to fill a vacuum. The last question I want to address is going back to that kind of who's your client question, and the issue of, okay, do you know, not only do you represent the creditors really as opposed to the entity, but let's talk about representing a company. You don't represent the board, you represent the company. And what happens when there start to be fraying around the edges between management and the board?
Very easily can happen. Management can have their own agendas. Management may, I've seen this repeatedly, goes off and forms its own buying group for the company. That creates some real conflicts for the management team itself and creates some, some problems for the attorneys and us in terms of what can be disclosed to management and what can't be, because they're now a bidder. So yeah, that's a real issue. Another one is, to what constituencies do you owe what responsibilities as a board? At some point in time, you owe, some responsibilities to virtually everybody in the universe as a result of this. We allow, the attorney-client conversations to build on that reality, and we work with attorneys in order to provide the right input to the board based on what the attorneys think is necessary under those circumstances.
Yeah, often the harder issue for us is when, as we often do, we conclude that management is incapable of managing the company and that not the right team to take it through and out of the bankruptcy. We think we have an obligation to tell the board. We don't usually get fired, but we've really kind of thrown a little gas on the fire. But if the management team is the reason you're in bankruptcy through poor management, you've got to make a change. And that's a little tougher for us, but we do it.
Well, and I think these challenges come up. They're really exacerbated in the vast middle market, as Henry was talking about in the last. Henry Miller was talking about in the last panel. We're all talking as if everybody's AMR, and they're not. There are a lot of closely held companies, and the problem that Barry just alluded to is really bad when you've got 3 out of 4, you've got a 5-member board and 3 of them are the CEO, the CFO, and the COO. How do you tell that board, well, you 3 guys kind of suck, and you've got to get rid of them? That's a really difficult conversation to have, because the board may very well feel that those people are so invested that maybe they can't run the company, but I think it's the rare management person who really looks inside him or herself and says, I'm just not the right person to do this. Some of them do, and then they'll hire a CRO, and then everything will be fine. But or you'll have a different set of problems. I guess I should say it that way. But it's difficult, to say the least, when the board has management. And that brings us to kind of the last question I want to talk about, which is the issue of closely held corporations. There are, what if it's a flow-through entity, and there's going to be cancellation of indebtedness income? How do you advise people who may themselves then end up having that tax liability?
We've had 2 of those cases in the last 15 months. Where all of a sudden the owner, and it's generally because we raise our hands and say you need to get the tax geeks in here, that's kind of the worst day of the CEO's life. When he realizes he's not only going to lose his equity value in the company, but he's going to get a big due bill from the IRS. And so we again work with tax counsel to see what we can do to mitigate that. And then, try to hold the CEO's hand to make sure that, we do this, and we work with them to structure whatever settlement with a buyer or whatever to pick up as much as humanly possible.
In the context of closely held companies, I've dealt with a few of those. When you come across an issue, your client is the company, and the company doesn't have a family. The company doesn't have a mortgage and a car bill, and there's people that run the company. You have to balance that. But the important thing, or the advice that I try and ascribe to, is that at the very beginning of the engagement, when you're going to be retained by this closely held company, make it clear who you represent. it doesn't mean that, you bring everything that you can to try and avoid certain situations. And as Henry's saying, you bring in tax advice when you need to. But, the bottom line is, your responsibility is to the company. And if giving advice means, unfortunately, you get fired, think of it the other side. What if, if you give advice and the client says, no, we're going to do it this way, are you willing to put your reputation on the line to take this company, through a process and try and defend it? I mean, again, you're remembering that you have to zealously advocate on behalf of your client. Your client's the company.
Yeah, fortunately, we don't deal with a lot of sole proprietorships, so we're mostly public company arena.
Well, that does make it a lot easier.
Never any graft in public companies, though, right?
Oh, we have graft, yes.
Right, exactly. Graft corruption, but other than that. Well, and that raises another interesting point, which is if you're representing maybe not a closely held or sole proprietorship or anything like that, but you're representing a portfolio company of a private equity company, and I want to go back to whether that creates problems with you with this interest standard in the first place. But let's say that the private equity sponsor wants to do a new value plan, wants to put in money. Well, I think it's pretty clear that if you represent the company, you can't negotiate that just with the private equity sponsor. And Jeff and I were talking about this a little bit before. My practice when representing, if a private equity client calls up and says, we have a portfolio company that's in trouble, I will usually insist that if I'm going to represent the portfolio company, that is, I would usually insist that the private equity guys get their own counsel. Now, they may not, they will have brought me in, certainly, but I can't be their counsel because there are certain situations in which they have either no interest because old equity no economic interest because old equity is out of the money by such a long way that it can never recover, or they may, in a happier scenario, they may be negotiating with my client, the company, for how much more money they're going to put in order to get an equity interest in the reorganized debtor. Do you guys think that relationship where, and you know how private equity companies are, they usually think they are the company, and so they're a little surprised when you say, well, actually I represent those guys, but not so much you.
Yeah, we'll see that. We'll actually encourage the PE firm to go get their own financial advisor. They usually don't. They think they're smarter than anybody else in the room.
Right, just ask them.
Yeah.
Yeah, well, your job at this point in time shifts because of North LaSalle to going and conducting a full and fair process so that you can get the deal done, because otherwise our judge is not going to confirm the plan.
Well, right, and then that's and then talk about the uncomfortable conversations that Jeff was alluding to. It's a very uncomfortable conversation when the private equity sponsor, who, remember, brought you in the first place, comes and says, I want to put in more money, and you say, well, that's not going to be enough, and moreover, I have to go out and run a whole process and give other people the opportunity too. They hate that. They think, well, this is ridiculous. I should be able just to put in what I think is the right amount, and who are you to tell me that I have to auction it? So then it's nice to have that Supreme Court decision there, but they still sometimes don't really believe it.
There's also when you have private equity lawyers, private equity parties who have been around distress enough times, they know a good amount, and they think that they want to drive home a result. Think, well, you can do it this way.
Right, exactly.
They think you can do it.
Even though I'm not a lawyer, you can do it this way.
Right.
We are about 2 minutes from 5:30. You guys have been incredibly patient and hung in. Thank you all for your attention, and we will see you at the gala.